The issue we're deciding here is more like that. It's more like the countless policy issues that are going to confront this country in the years and decades ahead. Will courts be able to decide these issues as to things they know nothing about? Courts that are completely disconnected from the policy process, from the political process, and that just don't have any expertise and experience in an area? Or are people and agencies going to do that?
Justice Elena Kagan on the sweeping implications for the country contained in two seemingly innocuous cases heard by the Supreme Court earlier today, with the power to radically remake American life. The case before the court is ostensibly about fishermen versus maritime agencies. Not exactly a barn burner, but it represents a broader fight by conservative activists to undermine the regulatory power of the federal government in what is known as the Chevron Doctrine, which says that courts should defer to experts at federal agencies rather than trying to interpret unclear rules themselves. If the doctrine is overturned, as Justice Kagan warned, that power is in the hands of the courts, many of which have been stacked with conservative judges by the same conservative activists seeking to have that doctrine overturned. The suit is backed by petrochemicals billionaire Charles Koch, as well as the notorious Alliance Funding Freedom, the organization responsible for the Dobbs decision and the efforts to ban abortion pill mifepristone. Not shockingly for this court, where there are conservative legal activists, there are a quagmire of ethical issues. Senate Judiciary Chair Dick Durbin has called on Justice Clarence Thomas to recuse himself from this case over his personal ties to Charles Koch, and there have been calls for Justice Neil Gorsuch to recuse himself over his personal and financial ties to another billionaire energy executive with stakes in the outcome of this case. Let's bring in law scholar and president at Mount Holyoke College, Danielle Hawley, plus Vox senior correspondent and author of The Agenda, How a Republican Supreme Court is Reshaping America, Ian Millhiser. All right, Danielle, I think we set the stakes here, but talk us through this. What are the implications of what would otherwise seem like a pretty esoteric case?
I have to say, I never thought as an administrative law professor I'd be talking to the American public about what is known as the Chevron Doctrine from 1984. I think it's a critical case, and Justice Kagan really put her finger right on it. The question is, who makes complex decisions about regulations that are passed by our administrative agencies? When we think of the Equal Protection, when we think of the Environmental Protection Agency, when we think of the SEC, all of these agencies that make regulations that really impact many of our lives, Chevron Doctrine simply says that the agencies are both politically accountable and the experts. What the conservative majority of the Supreme Court seem to want to do today is to take that power from the agencies and put it in the hands of judges who are politically unaccountable and who, as Justice Kagan pointed out, are often not experts in these areas of the law. So, for example, this case is about fisheries. We know that many judges don't know much about fisheries, whereas the agency that made these decisions is the expert in those matters. And that's what Chevron is really about.
Ian, we touched on the ethical issues in the introduction, but walk us through how Justice Thomas, Justice Gorsuch, how their impartiality is threatened here.
Well, Justice Thomas, I think, is unlike any other official in the United States, except for maybe former President Trump. He's a uniquely corrupt individual. But all justices are chosen because the White House that nominated them thinks they will do things that White House wants them to do. They are political appointees nominated by a partisan president, confirmed by a partisan Senate. And what this case is about is that there are all sorts of questions that have historically been decided by federal agencies. They touch on every aspect of American life. Everything from how should power plants limit emissions to what rates does your cable company charge is decided by these federal agencies. And what this case seeks to do is take that power away from these federal agencies that sometimes are controlled by Democrats and sometimes are controlled by Republicans, depending on what the voters decided to do in the last election, and instead give it to a judiciary that is stacked with lifetime appointees. 6 of the 9 justices are Republicans who are heavily vetted to do Republican things. So ultimately what this case is about is it's about taking power away from the democratic process, letting us say, do we want to have Democrats or Republicans make these decisions in every election, and saying instead we're going to permanently give this power to these 6 officials who serve for life, who are carefully vetted by Republicans to make sure they will do the things that Republican wants.
Well, and Danielle, there were echoes of what Ian just laid out in Justice Ketanji Brown Jackson's questioning during oral arguments today. Take a listen.
Maybe we just differ on this. I'm worried about the courts becoming uber legislators. If we're talking about a policy question, there are several reasonable meanings. Why should the court be the one to make that determination?
The danger there, right, of having multiple branches of government, which are supposed to be checks on one another. But in this case, really, it's becoming incredibly murky, the role that each is supposed to play. That idea of the courts becoming an uber legislator, I think that should be terrifying to pretty much anyone.
It really should. And I think the separation of powers questions, it's interesting that so much of what the Supreme Court is doing now is remaking the laws in the way that we have seen the Constitution over the course of many centuries, and more particularly over the course of 50 years. One thing that this case has in common with a case like Dobbs is that they would need to overturn a 40-year-old precedent in Chevron to grab that power for the federal courts. And most of this won't be decided at the Supreme Court level. These could be trial court judges on the federal side who are deciding really important matters about things like climate change, which we typically think of as in the hands of the political branches, now being put in the hands of unaccountable, lifetime appointed federal judges, which means they could make many decisions that would be in the interest of business or others without any check.
You know, I want to make a pivot and turn to another case before the Supreme Court that could potentially imperil Jack Smith's case against Donald Trump. This is Politico reporting, quote, "At issue is whether prosecutors and the Department of Justice have been improperly using a 2002 law originally aimed at curbing financial crimes to prosecute a January 6 defendant named Joseph Fisher. Should the court side with Fisher, it would also call into question the use of the law against other January 6 defendants, including Trump." What are you watching for in this case?
I'm watching a lot of things. I mean, I'm watching how the court decides the case. This case, even if they construe this law narrowly, so even if they say it doesn't allow that basically some of the January 6 protesters get off, that doesn't mean that Trump necessarily gets off. He could still be convicted under the more limited reading of the statute, but it would be harder. And then the other big thing I'm watching this in all of the Trump cases that are coming up to the Supreme Court, is how fast is the court going to move? Because Trump's strategy in his criminal trials, and especially in the D.C. trial, the one that really matters, the one that's about election theft, his strategy is to try to delay and delay and delay until the election happens. And then if he becomes president, he can order DOJ to drop all the charges against him. So we need these trials to happen, in a normal way with normal speed. And my biggest concern whenever the Supreme Court takes a case that touches on the Trump the Trump prosecutions, including this case, is if they drag their feet on it, they potentially drag out when this trial can start. And that means that Trump may escape justice altogether because the trial will be pushed till after the election.
Right. We keep coming back to this question of timeline. Danielle Hawley, Ian Millhiser, thank you both so much for joining us.